Good afternoon, everyone, and thank you so much for joining the Campaign for College Opportunity today for our webinar on the legal implications of the Supreme Court decision on race-based admissions. Before we get started, I'd like to remind you that today's session is being recorded and live streamed. At the end of today's panel discussion, we will have time to take your questions and answers. So as the webinar proceeds, please do drop your questions in the Q&A chat box, and we'll be sure to do our best to get to them during our session. With that, it is now my pleasure to introduce Michelle Siqueiros, the president of the Campaign for College Opportunity. Michelle?
Thank you, Audrey, and good afternoon, everyone. As the president of the Campaign for College Opportunity, speaking on behalf of our board, our organization, and most of all the students we serve, I strongly condemn and am disappointed by the Supreme Court's ruling in Students for Fair Admissions versus University of North Carolina and versus the president and fellows of Harvard College. Race-conscious admissions has been one of the most powerful tools resulting from the civil rights movement that seeks to address the lack of diversity on our college campuses. It's a tool that universities have leveraged to tackle the centuries-long legacy of racism and biases that have kept Latinx, Black, Asian American, Native Hawaiian, and Pacific Islander, and American Indian and Alaska Native students out of higher education. The Supreme Court decision to prohibit the use of race-conscious admissions in higher education impedes the very progress that universities have made to promote greater racial integration and inclusion in higher ed. Unfortunately, we know that discrimination and systemic barriers in higher education still persist today, and too many underrepresented students are shut out from our nation's top universities and colleges. This decision is a dangerous step backwards for our country, where over half of K-12 students are Latinx, Black, Asian American, Native Hawaiian Pacific Islander, and American Indian Alaska Native. In this watershed moment, we really must ask ourselves, what future do we want for our country and for our students? I certainly believe we have a moral and economic imperative to ensure that all students have an equal opportunity to obtain a college education. The academic, social, and economic contributions of students from all backgrounds are needed to benefit our economy and strengthen our multiracial democracy. We simply can't allow this decision to set us back. To the contrary, we need our higher education leaders to remain steadfast in their commitment to closing racial and ethnic gaps in college by removing inequitable practices and implementing proven and comprehensive tools that really affirm equal opportunity and help level the playing field. We must certainly also learn from our experience in California and other states that have been living under an affirmative action ban for some time. I saw firsthand the devastating impact of Prop 209 in California, which was passed by voters in the 1990s when I was a student at UCLA on an affirmative action fellowship. It was disheartening and shameful to witness immediate decline in the number of students across our UC campuses, and not just in the undergraduate schools, but also in our graduate programs. The proportion of Black and Latino freshman students at UCLA declined by more than half when you look at 1995 versus 1998, the first year that the ban on affirmative action took place. Black students made up 7% of freshmen in 1995 and only 3% in 1998. Latinx students made up nearly 22% in 1995. And in 1998, that number was 11%. Since then, the UC has worked to implement a series of race-neutral measures to increase diversity, such as outreach programs directed at low-income students and first-generation students, geographically based efforts, and of course, holistic review of college applicants. But make no mistake, while these efforts have allowed UC to make gains in representation, regrettably, there's still a considerable mismatch between the demographic makeup of California's college-going population and UC's actual enrollment. The shortfall is especially apparent at UC's most selective campuses, where African American, Native American, and Latinx students are underrepresented and widely report struggling with feelings of racial isolation on their campus. UC's decade-long experience with race-neutral approaches offers valuable lessons for California's private colleges and universities, as well as the rest of the nation. And while no tool will be as powerful as affirmative action, there are proactive, evidence-based practices that can and must be taken to ensure equitable college opportunity. Efforts like comprehensive review of applicants, dropping the use of the SAT, ACT, and admissions, and improving transfer pathways have shown promising progress in increasing the number of Black, Latino, and Asian American Pacific Islander students in higher ed. Those who have actively fought against affirmative action and attacked it as a preference have never directed their energy on the real preferences that favor wealthy and mostly white Americans, including legacy admissions, recruitment practices, athletic admissions, the overuse of standardized tests, and so-called merit aid, among others. The Campaign for College Opportunity, alongside our allies, will push for the dismantling of these practices. We will focus on ensuring that any negative ruling is not an excuse or permission for universities and colleges to return to an era of unchecked exclusion and segregation, which shut out generations of Latinx, Black, Asian American, Native Hawaiian, Pacific Islander, American Indian, and Alaska Native students from higher ed. We will continue fighting to ensure that every Californian, regardless of how much money they have, where they live, or what race, ethnicity they belong to, will have an equal opportunity to obtain a college education. I'd like to thank our co-host of today's webinar, Hispanics in Philanthropy. And now it's my pleasure to introduce Matthew Echeverria. He's a rising high school senior at Orthopedic Hospital Medical Magnet within the Los Angeles Unified School District. Matthew is a first-generation Latino student at a Title I funded high school in downtown LA in an area predominantly made up of low-income Black and Latino families. Matthew's involved in student government, cross-country, and volleyball, and in multiple research and advocacy-related extracurriculars. It's critical to have the student perspective, and Matthew will be sharing his today. Matthew, thank you for joining us.
Thank you, Michelle, and the Campaign for College Opportunity for inviting me to speak about the recent Supreme Court decision on race-conscious admissions and the impact it'll have on students of color like me across the country. My name is Matthew. Thank you. I am a first-generation Latino student and a rising senior in downtown LA. The area I come from is predominantly Black and Latino families, and most of my peers come from low-income backgrounds, including myself. We have had to work twice as hard to have the same opportunities and access to college-ready resources as students from more privileged backgrounds. Using race as a factor in college admissions to empower diversity in education has been important to combat a legacy of inequity and lack of access, especially comparing the historic privileges granted disproportionately to white families with more resources, legacy admissions, like you said, and other advantages. Despite going through a pandemic that disproportionately hindered academic opportunities for low-income students of color and facing challenging personal family situations like the loss of relatives and poor access to healthcare, education has been and will continue to be my priority. Education is so important for families like mine to bridge the gap between educational access and economic opportunity. When I first heard the Supreme Court decision to overturn race-conscious admissions in higher education, I was truly frustrated and concerned for the future of diversity at colleges and universities across the country. As a prospective college applicant, I maintain a 4.6 GPA, have been involved in student government, multiple sports, and I am in multiple research and advocacy-related extracurriculars. I have every intention to go to college and hopefully getting accepted into a competitive one. After such a devastating blow to long-standing legal precedent over a policy intended to combat generations of racial inequality, I feel deeply concerned and anxious that now private institutions in California, as well as colleges and universities across the country, may not recognize where I and so many students like me come from. I have worked extra hard to maintain my grades while going above and beyond to get involved, and I am proud of my Latino roots. However, I am not afforded the privilege of having tutors or a professional network assisting me. I'm not lucky to have college advisors guide me through SAT prep, FAFSA, or college applications. As a product of Guatemalan and Salvadorian parents, I hope to pursue higher education with these identities, and the SCOTUS decision refuses that to be my reality when it's been the reality I've lived my entire life. Growing up, I didn't have anyone with a college success journey to look up to, but I want to be that role model for my siblings, family, and so many low-income Latino students who wish to follow in my footsteps. I call upon college leaders, policymakers, and communities of color to take urgent action in order to continue to promote diversity, affirm equity, and ensure inclusion on their college campuses. And that starts by enacting policies that minimize the harm and damage to college access for Black, Latino, AAPI, and Native American students with the Supreme Court ban on race-conscious admissions. The equity implications of eliminating standardized testing, strengthening universal financial aid completion, promoting holistic review, doubling down on placement practices, providing targeted recruitment strategies to underrepresented communities, and campus resources or scholarships for students of color are all huge opportunities to continue and go beyond the intention of race-conscious admissions. I also advise colleges to be vocal about their commitments to DEI and advocate for safeguarding access to students of color at their institutions. There are simply no cons to building a diverse cohort of students because the power of higher education benefits hundreds of thousands of our communities with a strong workforce, lifts generations of families out of poverty, and ignites change on a magnitude unmeasurable to any one of us. Being part of a community with different identities and cultures is truly the ideal college experience, regardless of racial or ethnic background. It is so critical in order for us to pursue an inclusive and functional multiracial democracy. To my fellow peers and students concerned about our future, we must take action by actively engaging in policy advocacy and participating in the political process. We must share our stories with admission officers, superintendents, and school boards. I encourage students, leaders at universities to ensure our administrators, faculty, and counselors are effectively representing and supporting our communities. It's important to remember that youth are also capable leaders. So let's seize the opportunity to make a difference and take action. Thank you so much again for the opportunity and the work you all are doing.
Matthew, thank you. You certainly give us hope and inspiration as we lament a terrible decision, but you give us hope that the future is bright because you're a leader and you're going to take action. And thank you for everything that you do. Any college or university, but would be so fortunate to have you. It's with great pleasure I get to introduce our next two speakers as well, each with an important perspective to share with you and to really help us interpret this decision and understand where universities can go next in terms of affirming college opportunity for students. So first, we're joined by Art Coleman. He's the managing partner and co-founder of EducationCounsel. He provides policy, strategic, and legal counseling services to national nonprofit organizations, school districts, state agencies, and higher ed institutions throughout the country, where he addresses issues associated with student access, diversity, inclusion, expression, and success, faculty diversity, inclusion and expansion, and institutional accountability and accreditation. Art Coleman previously served as Deputy Assistant Secretary of the U.S. Department of Education's Office for Civil Rights, where in the 1990s, he led the department's development of the department's Title IX policy on race-conscious financial aid. as well as OCR's first comprehensive Title IX sexual harassment policy guidance. The first one was Title VI. Sorry about that, I inverted. Thomas Saenz is also with us. He's the president and general counsel of MALDEF and a board member at the Campaign for College Opportunity, currently serving as our board chair. And he's going to provide a legal overview as well. He has been, as all of you know, a tireless advocate for our nation's Latino and immigrant communities and has strived to ensure educational opportunity and equity for all Americans. Thomas leads MALDEF's national efforts to promote the civil rights of all Latinos living in the United States. Previously, as counsel to the Los Angeles mayor, Antonio Villaraigosa, Thomas also served on the four-person executive team to the mayor, where he provided legal and policy advice on major initiatives. Thomas was also the lead drafter of the amicus brief on behalf of Latino organizations supporting affirmative action in the Supreme Court case, Greta versus Bollinger. In 2020, Thomas and MALDEF led the charge to repeal Prop 209 through the Yes on Prop 16 ballot measure. As you all know, California banned affirmative action at its public universities in 1996 through Prop 209. So we'll start with you, Art. Can you please provide an overview of the Supreme Court decision? What does it mean? What does it not mean?
Thanks, Michelle. It's great to see you. Thank you for having me, and thanks to the leadership you're exhibiting with the Campaign for College Opportunity on this important set of issues. I'll give you a very sort of brief synopsis of the court ruling, what it did and what it importantly didn't do. I'll just begin by saying, and I don't say this lightly, it's actually one of the most disingenuous opinions of a Supreme Court majority I've ever read. I think it's just a remarkable that the court, while pretending to adhere to precedent, actually did everything but overrule past precedent. And I think it is important, as we think through what the court said, and obviously needing to adhere to the law, that we not, as some are arguing, overreact or overstate what the court said and did. So let me go quickly to the court ruling. In a 6-3 ruling in the UNC case, in a 6-2 ruling in the Harvard case, Justice Jackson recused. The court struck down the race-conscious policies that were before the court that were grounded in the educational benefits of diversity as the compelling interest rationale for both parties. I think what's sort of notable at the outset, to my earlier point, is while SFFA, the plaintiff in the case, sought to have policies struck down and the law declared invalid for the past 45 years, the court didn't take that latter step. It didn't categorically rule that all past precedent was invalid and overruled that past precedent, but it did everything up to that point on a number of issues. The court basically, with just the Chief Justice writing for the majority of 6 justices, ruled on 3 separate issues. First, with respect to the compelling interest that you need to have to justify the consideration of race, the court rejected the many interests that Harvard and UNC proffered regarding the benefits of teaching and learning, the benefits of workforce development, the benefits associated with innovation and problem solving, the benefits associated with engaged citizens and leaders, really quite the chorus of benefits that have a track record of decades of research and institutional experience behind them. But more importantly, were precisely the kind of interests that the courts in prior cases, in Grutter and in Fisher too in particular, the court had upheld. But notwithstanding that inconsistency, the court struck those interests down as too amorphous and elusive and insufficiently measurable and coherent. The court at the same time did note they were plainly worthy and commendable. So that's the one foundation for striking down the policies. Second, the court ruled that the design of the policies themselves resulted in negative effects and stereotypes in violation of the 14th Amendment to the US Constitution, which in the court's discussion made clear was coextensive with basically the same as Title VI standards applicable to private institutions that are recipients of federal funds. There, it noted the decrease in the number of Asian American students admitted over time. It constructed in a way that was, I think, is fact challenged, to put it mildly. It constructed college admissions as a zero-sum game, which is not the way holistic review works. And it considered that the preferences, as it construed it, in each case were for race on the basis of race alone, which is, I think, debunked by much of the underlying record that reflected the consideration of race in a nuanced, contextual way as part of a broad, holistic review. But nonetheless, that's the ruling of the majority. The third point, the court ruled, I think, very much inconsistent with past precedent, that this need for some point of termination on the consideration of race required more than just periodic review to assure compliance and a continuing need for the consideration of race, that it required an endpoint in time. Again, a point that the prior cases had never articulated and applied in the way the court does in this case. I will lift up the 2 points that I think are notable for the positive focus on issues associated with diversity and equity moving forward. First, the court was clear and uncategorical that, quote, universities may define their mission as they see fit within broad constitutional parameters. So I think that's critically important, particularly in the context where we're seeing the political fights and the legislative agendas in some states attempting to bring down the entire house of cards on the DEI front. There's actually nothing in the court's opinion that gives credence to that movement because it recognized the independent validity and deference to institutions in defining their mission. Secondly, and importantly, notwithstanding the fact that the court has in effect struck down the racial status consideration, that is merely the identity of the status of a student in the context of admissions decisions, it recognized the imperative that students be able to tell their authentic lived story, and basically said, I'm quoting here, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life. The touchstone of an individual's identity must be with respect to challenges bested, skills built, lessons learned, not the color of their skin. And so I think this preserves and opens a really important door with respect to valuing student experience, qualities associated with student experience that may be directly and expressly associated with race, very consistent with lots of practices among institutions, even to this day. And then I'll just close out with a very quick, let's be really clear what the court did not expressly address, and we can get into some of what carries over in the questions and answers, and Tom may elaborate on some of this. But the court said nothing about scholarships and financial aid. It said nothing about outreach and recruitment. It said nothing about pipeline programs and pathway programs. It did not address employment issues at all. And interestingly, it actually didn't give us any guidance for future thinking around the landscape, which is, I think, now clearly present, how we exhaust and expand the array of race-neutral strategies that will help us advance our goals. Tom, I'll pass the baton to you.
Thank you, Art, and thank you, Michelle, and the campaign, of course, for the important work that you're doing to address the oncoming impact of this Supreme Court decision. I will start by acknowledging what Art explained. This is a decision by the Chief Justice that is not characterized by candor. It is not characterized by careful logic or reasoning. It reaches a result that we could have foreseen coming from this court a long time ago. Indeed, this is the second decision by this Supreme Court majority in the last 2 years that overturns effectively long-standing Supreme Court precedent. Just like Dobbs a year ago overturned Roe versus Wade, this decision by the Chief Justice effectively, though not candidly, as Art explained, effectively overrules a 45-year precedent in Bakke versus University of California. Again, later affirmed by decisions by different court majorities in the University of Michigan cases and subsequently the University of Texas cases. It overturned effectively the Bakke precedent by basically outlining that an interest in diversity, which was well articulated by both Harvard and UNC, as Art explained, by rejecting an interest in diversity as sufficient constitutional support for race-conscious admissions, the majority effectively overruled 45-year-old precedent, long-standing precedent and practice in the area of higher education admissions. So we should be clear that race-conscious admissions, as we understood it since Bakke, is no longer the same after this decision by the majority. But I will then begin also where Art ended. This is not a decision, as it might have been, but it is not a decision that requires or even encourages anyone to muzzle themselves or to prevent themselves from presenting their whole selves, including their racial ancestry, their racial identity, and how discrimination and other social forces may have interacted with that racial identity to shape them as a person. This is not a decision that requires anyone to attend school or even to go into the application process without presenting their entire their entire identity, and all of what may have affected their development as scholars and future contributors to our society. It does so, as Art explained, by specifically stating that it does not prevent any university from taking into account in the admissions process itself how any individual applicant may have been shaped positively or negatively by their racial identity and how society interacted with that racial identity for that individual applicant. So very important to note, does not require anyone to somehow conceal how race, their racial identity, may have shaped their experience in this country. An extension of that is that it also does not require or mandate any policymaker in the area of higher education to ignore race, to pretend race doesn't exist, to bar themselves from considering race or racial disparity. It's important to note that the case does not have that mandate within it, because after Proposition 209 was enacted here in California some 27 years ago, the state and its policymakers were frozen for far too many years by the widespread belief that somehow policymakers could not talk about or consider race or racial disparity. That was not the case with Proposition 209. It is not the case with these decisions by the Supreme Court majority. Indeed, there are independent legal and certainly moral obligations for all higher education policymakers, even in crafting admissions, policies, and practices, to look at race and racial disparity in order to determine if it is justified, and when it is not, to take the important steps to eliminate the admissions criteria that are having a disparate impact, a discriminatory effect on students of color. Let me state that again. Even after this decision, there remain obligations under Title VI and its implementing regulations for all higher education policymakers to look at and consider race and racial disparity as they evaluate the criteria they use in admissions. Specifically, the obligation is to identify any specific criterion of admission that has a significant discriminatory effect on one or more racial groups, and where that discriminatory effect, that significant discriminatory effect, cannot be justified by some education necessity, then those policymakers are obligated not only to identify that criterion with unjustified significant discriminatory effect, but to eliminate it or change it to reduce or take out entirely any of the discriminatory effects on racial minority groups. So that's the second point. This decision does not mandate racial ignorance. Indeed, there remain in place legal and moral obligations to pay attention to race and specifically racial disparity in shaping higher education policy, including admissions practices and policies. And finally, it's important to note that despite the ongoing debate in this country about curricular subjects like ethnic studies or critical race theory, this decision has nothing whatsoever to do with curriculum. Moreover, it could have nothing whatsoever to do with curriculum, because in prior precedent, the US Supreme Court has concluded that issues, subjects do not have a race. So even if we label it African American studies, Latino Chicano studies, Asian American studies, those curricula do not have a race. Therefore, doing anything in the name of pursuing African American studies, Latino Chicano studies, or Asian American studies cannot be challenged as race conscious because those subject matters do not have a race as a matter of law. This means there's plenty of opportunity for not only students applying to school, but students and graduate students and professors in universities. There's plenty of opportunity for them to continue their important work in studying our history, our current sociology, and our future expectations through the prism of ethnic studies or racial ethnic studies. It's important to know that all of these present opportunities, important opportunities, indeed obligations, to take every step to ameliorate the potential impact of this decision, to limit its ability to reduce admissions of Black and brown students and other racial minorities to institutions, and to in any way change ongoing equity, inclusion, and diversity practices as a result of this decision with regard to anything other than the use of race as a systemic principle in race-conscious admissions programs. That is to say, we cannot allow the other side to overinterpret and misinterpret this decision in a way that would increase its impact, increase its negative ramifications. It should be limited solely to eliminating race-conscious admissions as a systemic policy, but it should be followed by efforts by policymakers, by administrators to ensure that we are aware of every practice, every policy that has a discriminatory effect and are taking steps to eliminate those policies with an unjustified, significant discriminatory effect on students or even staff members of color. Thank you, Michelle.
Thank you, Thomas, and thank you, Art. I'm just so thrilled to have you, and we can see the Q&A questions are really good. So I'm going to keep my part really short and turn this over to Audrey a little bit sooner than I expected, because I want to make sure I get to the very good questions in the Q&A. But first, to get started, you know, we're really interested in your reactions to, you know, what higher education institutions can actually do to ensure that they are abiding by the decision and also not overinterpreting it, and making sure that they are including a diverse group of students as they review admissions. Art, would you like to tackle that one first?
Yeah, so I think it is really important as you enter this space and think about the implications of the court's opinion, that we enter it with, despite the fact this is a moment of challenge, I actually think this is a moment of opportunity, potentially to do some of the really hard work that may not have been done as robustly as it might have in the past. Said differently, as opposed to simply going in to say, now we're limited in what we can do in admissions, what do we fix or adjust in admissions to assure compliance with the court's opinion? I would want to see institutions stepping back and seizing the mantle of leadership and actually saying, let's go back to first principles in our mission orientation. Let's think about what we might be doing differently and more broadly with respect to our diversity, equity, and inclusion goals. And that means looking at everything from, are we investing sufficiently? Are we targeting strategically on recruitment and outreach in ways that we've never done before? By the way, in an arena where the law gives you a lot more latitude to be very race focused because those practices are deemed inclusive. Could we think through, you mentioned this earlier, different conditions or requirements associated with transfer policies and programs to make it easier to create pathways of honest and authentic access? We should be looking at policies and practices that create barriers to racial equity. I've been pressing hard for conversations to actually recalibrate. For many years, institutions have maintained an array of practices that have some mix and match on the implications on racial equity. Maybe you made a decision 4 or 5 years ago with respect to a legacy policy or a transfer policy, an early decision policy. That calculus necessarily changes in the wake of a court opinion where they are eliminating the ability to consider the student's racial status as part of the admissions decision. So the question is, does your calculus from 5 years ago now need to change to accommodate that shifting landscape? And I think there are many more robust race-neutral strategies that probably haven't been fully exhausted, that within the scope of the court's opinion, we should be looking very hard and attentive to.
Thank you for that. Thomas, I wanted to ask you, and then I'm going to turn it over to Audrey, who's going to facilitate the Q&A. So put your questions in that part of the chat. But you talked a little bit about what policymakers could do. Could you tell us what you think civil rights organizations, advocacy organizations, many of us on this call, to hold higher ed accountable to ensuring that they don't return to an era of exclusion, or how do they preserve access for underrepresented students?
Well, I think that civil rights organizations will be monitoring and challenging those institutions that fail to take steps to look closely, as Art explained, to look closely at what they're doing with their admissions practices. And as Art suggested, the fact that you may have looked at them 8 or 10 years ago is no longer sufficient. And that's not just because of this decision, but that's because our ability through research, technology, and otherwise to identify and isolate the sources of discriminatory effects, racially discriminatory effects, has been heightened. And there is no excuse then to be relying on an aged decision by policymakers that they had no choice but to continue a particular criterion anymore. They've got to take a fresh look. And where we as civil rights advocates can identify significant discriminatory effects that do not lend themselves to any education necessity, we will be challenging in various ways those institutions to engage in that careful analysis and to follow up with decisions to change practices and policies. And it is widespread. You've heard discussed very well legacy preferences by both Art and Michelle, and you've heard discussion of standardized tests. But really, in this day and age, as our ability to isolate discriminatory effects get better and better, we have to look across the board. We know from the tremendous societal learning in the aftermath of George Floyd's murder that subconscious bias, subconscious stereotype affects everyone, not just police officers. It affects everyone, including those in education. And we may now have the ability to use algorithms, for example, to identify where indications of subconscious bias may impinge on a counselor's recommendation with respect to particular students, on a teacher's written recommendation with respect to particular students, and failing to attend to the effect that subconscious bias may have on some of these criteria could ultimately be a problem for higher education administrators. So I don't mean to make it look so daunting that you don't engage in that kind of careful analysis, but it's essential that we be comprehensive about limiting the ultimate impact of this Supreme Court decision.
Thank you so much, Thomas. We're going to get to some of the questions that we now have in the Q&A box, and I want to start off with a question. I think we've all heard that the plaintiffs in the Students for Fair Admissions case have been putting a request forward to colleges and universities to remove the boxes on applications where students would indicate their race and ethnicity. And indeed, we actually have somebody on the call or on this webinar whose college counsel has asked them already to remove the optional race or ethnicity box on their inquiry card. Is this something we should, colleges and universities should be considering to do? Is there considering doing? Is there anything in the court's decision that mandates this?
I'll start, Tom, and then weigh in. Number one, there's absolutely nothing in the court's opinion that would say stop collecting disaggregated data on the basis of race and ethnicity, period, end of sentence. In fact, there are independent federal obligations associated with that activity. And so let's be really clear, the mere collection of the information is not affected by anything in the court's opinion. There's a little bit of language that I think would raise the question of how institutions respond with who has access to that information and when. Said differently, if you've got a rolling admissions policy and program, how do you think about insulating the information about the emerging class composition associated with race and ethnicity from those who are making decisions? If I'm giving advice to an institution, I probably want to create some kind of firewall there, because I don't want anything to suggest that my admissions team, who are actually doing the work, including when they focus on a student's racial experience, could not actually address that question more broadly, but they should be insulated from the actual data to make sure it's not associated with their decision making.
And I absolutely agree with Art. In fact, I would say there's a problem, a potential legal problem, if you fail to collect data that would help you to do an analysis of racial disparity and racially discriminatory effects. What you need to do instead, as Art has explained, is limit access to that data. So for example, admissions officers perhaps should not see that, but it should still be collected. Otherwise, it will appear to civil rights organizations like my own that you are attempting to destroy the evidence of unlawful discriminatory effects, unlawful under the regulations that I described earlier. So if any institution precipitously refuses to collect the data, they are running a high risk. Again, steps like Art described to limit access so that those who are making decisions won't necessarily have it. They can read it in an essay, because as Art explained, the decision by the court continues to encourage expressions of how a racial identity may have shaped an individual applicant's experience. So they can't be completely shielded from that. But the checkbox, it would be fair to limit access to that checkbox information, but it must be collected or institutions are running a serious risk, in my view.
Thank you, Thomas, and thank you, Art. A few weeks ago, when the court decision was announced, we saw that the University of Missouri issued a statement that they would be rolling back their scholarship programs that were specifically targeted for Black and Latinx students. And so the question that we have is, does the decision legally impact race and ethnic specific scholarships? And if it does, is there any advice on how to maintain those scholarships that serve underrepresented students without violating the decision?
You're muted, Art.
Sorry about that. I just wanted to say my dog Molly is as upset by the decision as I am. On the question of financial aid and scholarships, I think it is a thorny area. In part, the court said absolutely nothing about financial aid and scholarships. And there's obviously an obvious distinction to be made between financial aid and scholarships. Even if you buy, I think, the ill-characterized zero-sum game that the court construed admissions to be, that's decidedly not the case when you're talking about increasing a pool of dollars available to all students coming from multiple sources, including those sources that may have race associated with the award of aid. So there are avenues to navigate here, I think, that distinguish financial aid and scholarships from admissions. That said, I think practically speaking, the answer is not get rid of everything that looks like or touches race associated with financial aid and scholarships. To Tom's earlier point, there's nothing in the court's opinion that suggests that. And to the extent the court is actually embracing student experience and qualities associated with student experience associated with race, there are design options in refinement of some race conscious policies that may yield impact in that context. And I should actually just call out although it's not stated specifically in the court's opinion, the court's final focus to say, yes, you can focus on student experience associated with race, that in the court's construction should be considered legally race neutral. And there's actually a snippet from Chief Justice Roberts' questioning during oral argument where he makes that very point. And so we should be really clear that when you lift up the kind of qualities for whom all students can demonstrate strength or power, those qualities can still tie to racial experience. I will then just say, finally, I think there are design options that may be at play that can be useful. One of them that I know a number of institutions have used over time, and I expect to continue to use moving forward, is a process called pooling and matching, where it's literally you're pooling the dollars coming from discrete private donors who may have some targeted interest associated with race, so that the actual decision-making is a race-blind decision-making, but the dollars are ultimately tagged to those donors who want to say, I want $5 million going to Hispanic students from Arizona, say, hypothetically, in the bigger pool of college funding. So the bottom line is, I think it's a complex area. We've got to navigate it carefully. We've got to be mindful of what the court did on compelling interest, but I think there are some creative avenues to pursue to mitigate any of the harm that might otherwise be present by virtue of the prohibition on the consideration of racial status.
Thomas, would you like to add anything, or do you want to go to the next question?
That's a terrific answer. I would simply add the disclaimer that neither Art nor I are giving legal advice, that every individual situation differs. I agree, this is a thorny issue. I agree, however, that if you are pooling and matching, you're not really awarding a scholarship on the basis of race. You're simply allocating financial aid in the most efficient way to support all students in need, and that's perfectly legitimate. I also agree with Art that if you were looking at giving a scholarship based on individual experiences, that's different from simply saying every student who checks a box that they're of a particular race is going to get a scholarship of X amount. The latter, if you're just basing it on someone's stated identity without more, is probably dicier legally than if you're awarding a scholarship based on an expressed experience and wanting to acknowledge those experiences and wanting to provide resources to those who have had those kinds of formative experiences of racial discrimination or the like. I would say this issue of scholarships is where we're likely to see much of the dispute, much of the discussion, much of the reform in coming years. But I think in the end, we have to keep in mind that no matter what happens, we have to end up with a system of financial aid, including scholarships, that is fair and that does not have discriminatory effects on racial minority students. So in the end, that has to be the goal, is making sure that institutions that have historically excluded and still do in comparison to relevant pools, students of color have to end up with systems that are fair to students who have traditionally been underrepresented in those universities and colleges. And if I could just make one statement about language. We have talked about diversity for many, many years. We have talked about diversity primarily when it comes to affirmative action because of that Bakke decision in 1978, and specifically because of the views of Justice Powell, who wrote the decision that ended up defining the law for a significant number of years. And in it, he said diversity was the only interest that could justify race-based affirmative action. And he specifically rejected what he called societal discrimination as a sufficient interest to support affirmative action. So we have shied away in the civil rights world sometimes from issues of societal discrimination in talking about affirmative action. This decision by the Supreme Court takes that away. And I want us to feel comfortable talking about equity and inequity. And that means looking at who's in the pool of potential college students, who are the high school seniors in a particular state or region, and what is their proportion of those who are racial minorities specific racial minority groups, and how does that compare who's being educated at the institutions, the higher education institutions? In the past, we might have shied away from that, but those equity issues should come full focus, full center. And that means it's perfectly legitimate for any and every policymaker, I hope, to understand that significant inequities, mismatch between who's in high school and who's in college, are by their very nature problematic and indicative of a societal problem that we need to fix. Now, we can't use it. We can't fix it using race-conscious means after this decision, but we certainly can as a matter of policy making center the fact that there is a significant mismatch disparity between who's going to high school and who's going to college.
Thank you, Thomas. I have two more questions, and there are a number of questions still in the chat, so we'll do our best to answer these following the session and post them on our website. But I have one more question for Thomas and Art, and then I've got one question for Michelle. The last question for Thomas and Art is really about the inconsistencies that we saw across the court's decisions this last June. But this specific question is about the military academy exception. Really, Roberts conceding that diversity is a benefit for our fighting forces, and whether or not the two of you think that that inconsistency can be the basis of a future appeal.
I have to start by saying my immediate reaction to that footnote that attempts to at least preserve a potential carve out for our military institutions, schools, was nothing but one of cynicism. It felt like a kind of throwaway, unthought through point. It clearly comes from the compelling arguments that the Solicitor General made almost exclusively to advance the educational benefits of diversity rationale in talking about the imperative associated with racial diversity in our military ranks, including our senior military ranks. I'd say 2 points, maybe neither one of which is terribly helpful in a moving forward strategy. One, the irony of carving out something for the military that's actually ingrained in the very fiber of the thing the court has actually effectively just struck down is not lost on anyone. It wasn't this separate thing, it was part and parcel of the entire diversity rationale. So there's, if I talk about intellectual incoherence, to be kind, this is one more manifestation of that. I do think it does telegraph, however, the notion that the court in its very clear, albeit technical fashion, did not wipe out or eliminate the universe of all potential diversity-related interests that might justify certain race-conscious practices. It simply tackled basically the universe of what we've seen in the cases moving forward. And so could you make the healthcare or case about law schools or a case about the military in a distinct and more concrete way than the cases were made here at an undergraduate level? I think potentially. So that door is open. I think it's a relatively small crack given this court, without any guidance about what you do when you step through the crack in the door in terms of what's there in terms of a landing pad. But it's at least an opening. I'm just very cynical about what the court was really doing there. Tom may have a different take.
I agree. I think it was put there for instrumental reasons. As Art has explained, it was to neutralize a particularly appealing set of arguments and arguers on this issue, namely those in the military. I am not optimistic that it is a basis for any future challenge to this outcome. The inconsistency is very likely to be resolved in the other direction, to eliminate the military exceptionalism that was articulated in the Chief Justice's decision. So I don't want anyone to leave the conversation believing that that glaring inconsistency is somehow going to provide the basis to overturn this decision with respect to higher education admissions. It will not have that effect with this court at any point in the near future.
Thank you both for that. Michelle, we have some questions in the queue about what California has done past our ban on affirmative action that applied only to our public universities, and how some of those responses have panned out for students. So it's two parts. How has the eligibility in the local context, whereby each student in a high school who applies to the UC has some extra consideration if they're in the top % of their class? How has that been working out? As well as holistic review, whereby the UC is employing a number of factors as they make their admissions decisions, including where a student attends high school, parents' educational level, things like that. How are those things working? Are they widely used? Is it making a difference?
Well, I'll start with concerns about, top % plans in general. We're actually going to have an expert brief by Stella Flores on that topic, and I'll share more about that as we close out the webinar. The concern is that while the UC just does provide admissions to every eligible high school Californian who meets the requirements, that eligibility, that offer of admissions right now is only to the University of Merced, and less than 1% of students who are eligible and are admitted that way actually accept admissions to UC Merced. So we call it sort of your guaranteed admission in pretty much in name only. So that's obviously a concern. In terms of the second piece, I think the University of California is certainly a good model around holistic comprehensive review of applicants. It took a long time following Prop 209 for the UC to really identify a better strategy and solution for reviewing applications that are fair. And we have a brief coming out on that topic by expert Michael Bastedo on how colleges and campuses can really explore that as an option.
And any thoughts on holistic review, Michelle?
I just shared that, Audrey. I think you're multitasking.
It's now my pleasure to turn it back to Michelle to close out our webinar.
Thank you, Audrey, and thank you, Thomas and Art. I know we have a lot of incredible questions still in this webinar. It's clear that an hour is just not enough time, but we will be putting out in conjunction. Art Coleman is preparing a detailed summary analysis of the decision and what is possible to do. So please be on the lookout for that. I also want to thank Matthew. Matthew, you are the reason we do this work, and to all of the students out there, you should know that many colleges and universities understand the benefit of having you in their classes and encourage you to continue to ensure your spot at one of those campuses. I really want to ask all of you to take action, for us to be able to impact and ensure equity in higher education. We need to speak in one voice and urge policymakers and college leaders to act on behalf of students. So please explore our website and learn more about our effort on affirming equity, ensuring inclusion, empowering action. It's a national initiative that we've launched at the Campaign for College Opportunity to really ensure we are communicating the true breadth of the decision and providing resources on that interpretation, and ensuring that it is not being overinterpreted and that we do use the tools available. And as Art said earlier, use this as an opportunity to attack the things that we know right now are not equitable in higher education in order to better serve students. On July 20th, we're going to release the first in the series under this national initiative. So we invite you to join us on July 25th for a virtual event with legal and higher education experts, where we're going to share solutions for what colleges can do to make college admissions more equitable. That includes a deeper discussion on holistic review, on ending discriminatory practices like legacy, like recruitment, early admissions, demonstrated interest that really don't serve all students equitably. and a paper on standardized testing and admission. So those will be released, the papers themselves on July 20th. The webinar will happen the following week on July 25th. Obviously, the future of this nation depends on our ability to embrace and celebrate and ensure that all talent in this country is tapped and is given the opportunity that it deserves, so that every American, regardless of where they live, their income, their zip code, has a true chance to contribute to our society and live their dreams by getting a quality higher education. And with that, thank you everyone for joining us. We hope to see you soon.